Okay, Mr. Jones, come on up. Does she have a failure to appear? Or, okay, Billy Tarasucio? Can you hear me in the victim room? But she needs to fill out a notice of appearance. Yeah. Yeah, this isn't the right form. I mean,
That's for the, yeah, she got a notice of appearance. Let me get it.
okay. Okay. Is this is Miss Tarasasio there? Can you hear me now?
Okay, yes.
Okay. Is it Billy Tarasasio?
It's Tarasio.
Tarasio, okay. Did you fill out a notice of appearance?
I did, Your Honor. The victim advocate here stated that wasn't the appropriate paperwork and took alternative paperwork.
Yeah, it should be a notice of appearance. And are you going to be appearing on behalf of the victim at all future hearings?
Yes, Your Honor.
Okay. And did you need me to read the victim's Bill of Rights information?
No, Your Honor.
Okay. All right, sir, state your name and date of birth.
Roland Jones, 3/14/73.
Okay, you're here on a Superior Court grand jury warrant, which means the grand jurors met, they heard testimony, and they found probable cause on one count of conspiracy to commit custodial interference. That's a Class 6 felony. And one count of false reporting, Class 1 misdemeanor. I could not find that you're indigent, sir, based on your financial affidavit. So either one of two things can happen. One, you can hire your own attorney, or two, you can give more information to the next judge about your financial status, and they can determine whether you are eligible for court-appointed attorney, okay? All right. Counsel for the state, did you want to be heard?
Tara Procco for the state, and yes, Your Honor, just briefly, the current grand jury warrant bond is in the amount of $50,000. We would ask the court to affirm that bond amount. We're also asking that electronic monitoring be ordered as well if that bond gets posted. The defendant was picked up yesterday attempting to fly out of state, necessitating this grand jury warrant due to this behavior as well as the nature of the underlying charges. Both conditions are appropriate.
Okay. And the attorney for the victim, did you want to be heard?
Yes, Your Honor. My client, Samuel Jacob Gochener's position is that $50,000 is not enough and that bail should be denied or increased for three reasons. The underlying issue in this case is that Roland has assisted his daughter, Madeline Jones, in disappearing and has been extremely successful in doing so. Despite hundreds of hours of police looking for her across half a dozen states, they've been unable to locate her. There's also evidence that they have been planning this disappearance to Texas for some time, asking friends for money, buying plane tickets, printing out maps. They know what they're doing. And finally, the ties to the community that they had are minimal at best. After Madeline disappeared, they publicly declared that my client kidnapped and murdered Madeline Jones. They held multiple fundraisers from their community to support their investigative efforts, claiming that they publicly hired a private investigator and attorney with the funds they raised. It's since been realized, and the public realizes, that they did not use these funds to hire a private investigator, and probably in fact used them to help hide Madeline. Additionally, they're active members of the LDS Church, but they also were accepting church money from the LDS Church to pay their bills, all the while taking out thousands of dollars to hide Madeline and my client's baby, William Gouchenour.
Okay. Thank you. Sir, your next court appearance is going to be an arraignment hearing on October the 5th at 8:30. I am going to set and affirm the bond set by the grand jury judge, which is a $50,000 secured appearance bond. I am going to place you, if you are able to meet that bond, I'm going to place you on electronic monitor, an ankle bracelet. Okay, and you're going to have curfew hours, and those are going to be set by pretrial services if you're able to bond out. You're going to have a long list of conditions, including no contact with your co-defendant. Do you understand that?
Would that be my wife?
That would be your wife. Absolutely no contact with each other. Somebody will have to live somewhere else, but you are not to have any contact with each other. Do you understand?
I'm a little bit confused, and I'm also confused why I'm not allowed to offer any defense to the claims that have been made.
Okay, this is not the court hearing for defense. You haven't been found guilty of anything. As I said earlier, at this point, all this court is going to do is determine whether you are eligible for a bond or not. And as I said earlier, another judge made a determination, the grand jury judge made a determination that your bond is going to be $50,000. Okay? You're going to need to either hire an attorney, and then you can discuss with them what your defenses would be on these two charges. But at this point, you're going to have a $50,000 secured appearance bond, followed by electronic monitoring.
I'm just not sure what to do because I really don't have anywhere near the kind of money that everyone's thinking I am. They have my bank records. I'm pretty much broke from all of the legal things that have been going on.
Well, if you can't meet the $50,000 bond or go through a bonding company, you'll be staying in custody at least until your next court hearing of October the 5th at 8:30. Okay? Now, you're going to have a long list of release conditions if you're able to post that bond. One of them is that you will have no contact with your co-defendant. Do you understand that? Is that a yes? Okay. Step to the clerk and get your paperwork.